Hello friends, in this video we will discuss regarding the doctrine of Kevit Emptor. The normal meaning of the doctrine of Kevit Emptor is let the buyer be aware. So whenever you are buying anything, before the seller is aware, you should be aware that what you are buying. So Sales of Goods Act 1930 says that even though the responsibility is there on the shoulders of the seller, but the buyer should also be aware regarding what he or she is buying. So, doctrine of Kivit Emptor says that there is a presumption under the law that the buyer should be aware. The principle of Kivit Emptor is based on the presumption that buyer purchases the goods relying upon his own skill and judgment. It means buyer should be aware himself. He should have own judgment as well as skill. In the nutshell, doctrine of Kivit Emptor says that when the buyer does not rely upon the skill and judgment of seller, but he is relying upon his own skill and judgment, right? Then the buyer will be responsible for whatever he has bought. But buyer should be given a chance to examine the goods. If the buyer is aware, still he is not given the chance to examine the goods, he will not be liable. The buyer has not specified the purpose for which he is requiring the goods. It means he is relying upon his own skills. He is not depending upon the skills of seller. So he is not telling the purpose for which goods he is buying. Then the seller is not liable for any loss suffered to the buyer due to those goods. So the buyer should be aware when he is buying according to his own will, whatever he is asking, seller is providing, seller will not be liable. For example, Rafi has gone to a departmental store and has picked up a shampoo along with other articles, right? Later on, when he used the shampoo, it was infection on his scalp. And for curing this blisters on his scalps, he never mentioned this particular purpose to the seller. He simply asked for a specific shampoo and the seller provided him. So it was held that Rafi himself is responsible. He cannot sue the seller for the losses suffered. But now, the seller is not liable, buyer is liable, but there are certain exceptions to this rule. It means Kevit Emptor has certain exceptions. Here are some cases in which the seller will stand liable for any losses suffered to the buyer. So these are the following certain exceptions. First point, when the buyer makes the purpose known to the seller. This we have already discussed in case of implied condition as to quality or fitness. So whenever the goods are being sold and that purpose is told to the seller, right, expressly or impliedly, in such cases the seller will be liable, buyer will not be liable, because the purpose is made known to him. We are telling the purpose that I am buying the goods for this purpose. So it is the duty of the seller to provide those goods which are suitable. Second is merchantable quality. This also we have discussed in case of implied conditions. The goods should be fit for consumption. Even though you have not made the purpose known, you are buying a product. It should be fit for consumption. If it is not fit for consumption and the seller is dealing in such goods on daily basis, the buyer will not be responsible, the seller will be responsible. Third is sale of an article under a patent or a trademark. When the buyer demands a product or a specific patent or trademark product and does not rely upon the judgment of the seller and suffers a loss, then the buyer cannot held the seller liable, but under few circumstances, seller will be liable. Let's take the example. The buyer asks the seller for an article which will fulfill certain purpose. The seller in response sells an article of a very well-known trade name. The buyer suffers a loss. In that case, the seller will be liable even though the product was sold under a trademark. So here the purpose was made known. Consent by fraud. When the consent of the buyer has been obtained by fraud, then also the seller will be responsible. And the last point is usage or trade. whenever there is a usage of the trade that in our trade KV tempter will not be applicable. Of course, in those cases, KV tempter will not be applicable. It means parties have already decided expressly that KV tempter will not apply in our trade. So when there is a usage of trade, that KV tempter will not be applicable. In such cases, the rule of KV tempter will not be applied. So these are the 5 exceptions. The 6th exception is where the seller conceals a latent defect. Latent means which is not revealed by ordinary examination. It is called a latent defect. As I already told, there are 2 types of defect, latent and patent. Patent can be noticed after reasonable examination, but a latent defect cannot be examined after an ordinary examination. It means that is hidden. So it means in such cases, when you are selling such goods which have a defect but that is not very much visible, so and buyer is suffering a loss, in that case the seller will be liable. The rule of KV tempter will not be applicable here. A seller sold 50 wooden almirahs to the buyer. Buyer bought the almirahs after examining it, but later on he found that almirahs were affected by termites and they were unfit for consumption. So here, even through the reasonable checking, buyer could not find the defect. Here the rule of KV tempter will not apply. The seller will be liable as it was a latent defect. So this was all about the KV tempter. What is KV tempter and what are the exceptions to the rule of KV tempter? Thank you.